And good morning again here on Wednesday, April 2nd, a little after 11 o'clock. We're just from our published, sort of why we had committee time. We weren't sure how long it would take us to get through miscellaneous DMV bill. We're back with Damien to keep going. We sort of just ended with section 18, unless there were other questions, 15, 16, 17, 18. We're on section 19, page 23.
Right.
Yes.
I have to pick it up here so we can get through. So this one here is setting out specific requirements for commercial driving instructors. So if you come down to page 24, it provides requirements for commercial motor vehicle instructors, whether they're behind the wheel instructors or theory instructors. And it sets out specific requirements relating to holding a CDL of the same or higher class and having 2 years of experience driving a commercial motor vehicle of the same or higher class if you're behind the wheel instructor. And then on page 25 for, whoa, too fast there. And then there's the alternative, which is CDL of the same or higher class, 2 years experience as a behind the wheel instructor, and any additional state requirements. And then if you're a theory instructor, CDL of the same or higher class, 2 years experience driving a commercial motor vehicle of the same or higher class, and any additional applicable requirements for a CDL of the same or higher class, and 2 years experience as a behind the wheel instructor, and any additional applicable state requirements. So these are just basically establishing the basic requirements to be behind the wheel or theory instructors. And the department can talk more to the sort of genesis of this language. This was their proposal.
You want to do that first, or you want to take for Representative Keyser's question?
I will just add quickly, this is just coming into alignment with the federal regulations.
Which is too bad, but necessary. I get it, because some of my constituents have said there's like one or two of these guys that can, or people that can do CDL examinations. And so there's a big timeline between trying to get the trades going and all that. So moot point. Thank you.
We're gonna have a big having man who handles our starter education for CDL. He's going to come in, I think week 3, a couple weeks. So he has a whole presentation on this as well. So dive into.
It's a lacking. There's like many things in the trades or these type of things. It's lacking in the ability to do it because there's no personnel. So this is just what we have to do. It's too bad.
All right. So section 20. On page 26 is motorcycle instructors. And this is actually easing the requirements to become a motorcycle instructor. So instead of current law, which is 4 years of licensed experience as a motorcycle operator during the last 5 years, this requires 2 years licensed experience as a motorcycle operator during the last 4 years. So just easing those requirements there to enable more motorcycle instructors.
Does that imply we have a shortage, or is that in line with some other state, how other states handle it, or?
Correct. No, we have a shortage here for motorcycle instructors. But again, we're trying to make that alignment across. CDL is a different beast, I would say, but it's trying to make that alignment there as well.
Okay. Thank you.
Okay. So the next section is getting into the purchase and use tax. So we're in the Title 32 briefly here for a couple of sections. The first changes here are in the definitions. And if we go on to page 28, you'll see that we're replacing the NADA Official Used Car Guide New England Edition with JD Power Values. JD Power acquired the rights to that, and so they've changed the branding. And then the next change in here is just some numbering changes and switching out the word such for the. If you work with me for any period of time, you'll know that I hate using the word such unless there really is no other word. And so I tend to switch it out. I find it to be really stuffy. So that's just me. And otherwise, it's just switching to the terms that don't reference gender. So, and then the computation of taxable costs. Again, we're making the switch from the NADA guide to the JD Power values. And then we're also adding in language to provide, and this is on page 30, that the commissioner may develop a process to determine the value of vehicles that do not have a clean trade-in value and JD Power values, and that the commissioner may compute the tax and assess the tax due and notify the purchaser verbally if the purchaser is at a DMV location or immediately by mail of the amount of tax due. And again, as I mentioned earlier, this doesn't mean that our commissioner has to be at every DMV location. It just means that the DMV staff on the commissioner's behalf will do this.
What's a commissioner may develop a process to determine the value of vehicles? What, when it's not clear, kind of a clean trade-in value, what kind of, the reason for this piece or the idea, what was the genesis of what we needed to, what kind of vehicle isn't in there? And was this a regular occurrence of things, or is this cleanup? The idea, what drives the idea that, is there a lot of problems where we don't know the value of the vehicle? Is that what?
So this is tightening up some language because we've recently had some cases through our hearings department with people contesting the value of what the vehicle is. So this language was missing, that it was kind of a missing piece within the statute. So it allows us to computate the non-clean trade vehicle that JD Power would capture and kind of develop a process for determining that value.
So Vermonters appealed a value decision that they had to pay tax on.
Yep,
There's a hearing department that it goes to of some sort, and we're gonna hear more about that and how that works. And then out of that, you're saying that we need to be more clear that we can do, you have the authority to prescribe a different value.
Yeah, so it's in policy and practice, so the court through DMV policy, which is, I think, in the early 90s, it was developed, so they were able to follow it. This is just kind of putting it more officially in statute. There's a missing piece, I guess.
Okay, thank you. Representative Wells?
Yeah, that JD Power is just more accurate. Simple as that.
Yeah, so again, JD Power is purchased by
NADA was purchased by JD Power.
Yeah, so
Okay.
it's just
Yeah, same thing then.
Same thing.
They're just new boss. Yeah. You were talking about problems that I'm sure you saw it all the time. You'd buy a rig, you'd get somebody to say, I paid $10,000 for this. And so I only want to pay tax on that $10,000 purchase. So that probably was the root of changing, being more accurate there and having a set price because they know exactly what a vehicle's worth.
yeah. So it's just some context. We've recently had one that came in $500 for a $30,000 pickup truck.
And
So this allows us just clean up language in here.
It has some dents in it.
It was nice of
Have to be
the
total.
regular trucks that are out there.
It was up on blocks.
All right. So section 23 sets a timeline for requesting a refund for an overpayment of the purchase and use tax. So you have to request the refund within 1 year after paying the tax. So current statute doesn't include a timeline, so this is just adding that in. Section 24 gets us back to registration fees. This is also dealing with refunds. This is if you've lost your vehicle because it's been totally destroyed by fire or through a crash or wear and tear. Although I'm having trouble imagining the wear and tear scenario that fits within the time period here. But this allows the commissioner, after the cancellation of the registration and the owner returning to the commissioner, currently you have to return your registration certificate or the number plate or number plates. You can imagine how that would be difficult if you had a total loss through a vehicle fire. So this allows the commissioner to accept other proof of cancellation to the satisfaction of the commissioner, and then to issue a refund based on that for the unexpired term of the registration. Okay, next we're on the fuel tax refunds. So this is taking current law on fuel tax refunds. And what we're basically doing here is under the current law, you have to request the refund within 33 months. This would change that to 12 months. So instead of 2 years, 9 months, you would have just 1 year after the date that the amount was credited to request the refund.
Yeah, what would be the basis for requesting a refund? Like what situation would this happen in?
So the language here, so go ahead, Commissioner. You're going to do a better job than I will.
In simplest terms, so these are your large distributors, and they have some fuel products that are kind of taxed on the front end, but for receipts, documentation are supposed to be taxed, or we get a discount rate. There's a more elegant way that our finance person's coming to give a full presentation on this, but take for instance your dyed fuels, dyed diesels. If it's taxed on the front end, it doesn't need to be taxed. You can request a refund. Currently, our finance staff is getting these packets for 33 months worth to the extent that I can't even scan them in. So by shortening it to 12, it's just administrative ease.
Yeah.
Efficiency, I guess.
But this is really for dealers.
Yeah, this is the large bulk suppliers, wholesalers.
Damon, do you know if there was any testimony taken on this in the Senate?
I was not present for any testimony on this. That being said, yeah, I was going to say I'd look to the commissioner because I think he would have been there if there was. So, yeah.
Well, SP and JRL reside right in the neighborhood. I suspect that they'll want to, maybe they won't. I don't know. I don't know enough about it. I just was saying, I'm curious if there was. So Representative Pease.
The only thing I can say from personal experience is that, and this goes into dyed and clear diesel. You have clear diesel, which is taxable, and you pay tax on it, but then you decide to sell it as dyed, then you have but then, I mean, that, you don't do that as a distributor. I mean, that's a lose-lose, but that's one situation. The other situation that I've seen come up, and it happened up in Winooski near Costco, is when there was a fire. And that clear diesel was basically contaminated. So there it was, and you had to get rid of it. Would you ask for a refund of 50 cents a gallon? You might. But this seemed awfully odd.
I might not have been given the right context of it.
Got it.
But our finance director, she's coming in, and our auditor for the gas tax, she's doing a whole presentation for folks. It's much more clear when they explain it than what I'm trying to spin up, but it has to do with their distributors and wholesalers, and they get a large amount of receipts that can't get processed. And there's some out of state suppliers that send in, they wait the whole 33 months and those send in a huge stack and we can't process it, or we do, but it's to the extent we can't even scan it into our system. Yeah, it's so large. Okay.
That's another section of DMV 101 over the next multiple. There's a lot going on there. I don't have any idea the amount that happens. So we are digging in. We appreciate your staff coming in to educate us.
Okay. All right, the next is alteration of odometers, section 26. So there's a lot of,
Did we skip? 24?
nope,
Oh.
that was the credits and refunds for the fuel tax. I went through the various refunds pretty quickly. So, and I didn't mention sections as I was going through them. So I think we got all of them.
Oh, I see, sorry.
We can back up. We need to.
So you're gonna see that looks like there's a lot of change to the language here. What I was just doing is changing it to the present tense or active voice just to make it flow a little bit better. So basically, you can't sell or cause to be sold or attempt to sell or cause to be sold any motor vehicle, etc., if the odometer, hubometer reading, or clock meter has been changed, tampered with, or defaced, unless you disclose that information to the buyer. So we're updating all of that language just to clean it up. And we're getting rid of this sort of bizarre explanation of what these things are, because they're commonly, I mean, everyone on the table here knows what an odometer is. A hubometer is that thing you'll see on trucks rocking back and forth while they're driving. A clock meter, similar, it measures distance here. So we're getting rid of language here which says, which under normal circumstances and without being changed, tampered with, or defaced, is designed to show the distance the motor vehicle, etc., travels. And then we're cleaning up for present tense, and then we're adding in the clarifying language, and this was the original change that was being added in. A person who violates subsection A of this section shall be fined not more than 1,000 for a first offense or 2,500 for each subsequent offense. This section is the epitome of DMV's counsel and me getting together and saying, this reads really badly. Can we make this more clear for someone who's reading it? That's all we're doing here. We're not actually changing the substance. It is a technical change. There's a long explanation for a technical change, but it's a lot of changes there. The next 4 sections, I think, are all adding a cross-reference to the definition of conviction, because there have been issues, as I understand it, some of them have occurred in family court, where what our motor vehicle law defines as a conviction is not being treated as a conviction for purposes of referring information. The DMV can speak to this better than I can, but we're adding in these cross-references to just make it extra super clear that this definition that we said in 23 VSA 4 applies to the whole title is cross-referenced here. So we say, yep, and look back at that definition that we said applies to this section. So that's all we're doing in these sections. So 23 VSA 102, we're adding the cross-reference at the very bottom here on page 36. Same thing in 108, adding the cross-reference in 23 VSA 1709. This is the Judicial Bureau reporting back. We're saying, as used in this section, conviction has the same meaning. 1200 for that subchapter. And then that brings us to the drunken driving technical corrections. So any questions on the conviction language? Yeah, if you're reporting this bill, that's a section, that's a good one to volunteer for. You're not changing law, you're just adding a cross-reference. So section 31.
Those that didn't present on the T-bill, better be queued up for this next bill. I might want to think about that.
Yeah, that'll be quick and easy. This section here, we're adding clarifying language here. So as you all know, with the legal limits for drunken driving, it's at or above the legal limit. Some of the language as you'll see here, if we take out the at or above, alcohol concentration above legal limits for civil suspension. And so we're clarifying that no, it actually is at or above the legal limit. And that's how the law has been applied, but it doesn't read that way throughout. So that is the change we're making in this section. So you'll see several instances where we just add in the words at or, and then a couple instances where we're changing to a term that's non-gendered. So that is, I think that takes us several pages down. It's a very long section. And then we do make a change in 1205D. The reason I split out 1205 subsection D from the rest of 1205 is because this is a separate sort of substantive change. And this is providing that, so currently you get a notice of intent to suspend your license. And that notice currently says that this serves as a temporary operator's license and is valid until the beginning of the day of the suspension. The problem is if someone already has a suspended operator's license or doesn't have an operator's license, that we're legally giving them a temporary operator's license. And so this will be changing, the form will be changing, and this will no longer say, and they're also not taking away the operator's license card. So the person will still have that. And if you didn't have an operator's license, you don't have an operator's license card that's valid already. So this is fixing that issue.
Representative Pound?
So when you get your license suspended, it's not like now, it's suspended starting next Monday?
So as it relates to DUI, for DUI, I'll try to be brief on this, we can discuss later more. So if I arrest someone for DUI right now and I bring them to barracks or police station process, and they subsequently either refuse or blow over a .08, you would issue them both their court date and several other pieces of paperwork, and then you would issue them this notice from the judiciary that says your license. I used to have this memorized. It's like 10 and 7. If you want to appeal your suspension for DUI, you'd have to send in a written notice asking for permission, if say for work or medical reasons. And then subsequently, your license will go in under suspension on this date. I believe it was 10 days, 7 and 10. So yes, it doesn't go in effect immediately unless you already have a suspended or no license. There's a brief window there that you can have your license.
Due process.
Yeah.
So, yeah. So,
Can't speak from experience.
all right, the next is a fee for bulk electronic records requests. The department can speak to this much better than I can. But my understanding is that this reflects basically the fees that are already being charged for bulk electronic records. So this is when someone does a large public records request and you're producing these huge reams of records. And so right now it's 30.3 cents per record. And this is recording that in the statute. So next is registration fees for trucks. This is a long section, but it's really easy to summarize. If I take you first to this was another instance of finding something that doesn't align with the current law and then figuring out why. And it's this language that we're deleting. Here, I'll bring it up to the top of the screen for you. Fractions of 1,000 pounds shall be computed at the next highest 1,000 pounds, excepting, however, fractions of hundredweight shall be disregarded. What the heck does that mean? The way it's been interpreted and what we're now just putting in the statute is that the first 100 pounds over 1,000 pound cutoff is included in the next lower 1,000 pounds. So if your truck is 40,050 pounds, you're in this 30,100 to 40,099 pound class. And it determines your registration fee. And so that instead of having that fractions of 100 weight and then having DMV have a schedule that actually records these weights for clarity, we're just putting the weights in the statute so that this lines up with the schedule. And we, Evangeline, the DMV council, and I puzzled over this, trying to figure out who, when they were drafting this, thought that this would be the best way to phrase it. And we couldn't come up with a good reason to leave the phrasing the way it was. And so this is the change that was put in. But it just lines it up with the current practice. So it's not actually changing any fees or the amount that any truck owner would pay to register their vehicle. And that brings us back to the purchase and use tax. These are a couple of technical changes here.
Things that are driven out of the whole updating modernization of what pointed out, issue after issue to have these many clerical spots or what technical changes? Or is that just being the new guy on the block? You know what I'm saying?
No, I would say, I'd say it's fair. It's a mix of between updating with the new system. We also have fairly new legal counsel, probably been there a year or so, and she's been going through as well and identifying areas that don't make sense, I guess, or not easy to read. Just trying to clarify it. That's where some of these outs are coming from. It's we're trying to make it simple for bloggers. So I can't even understand the chart, obviously.
Yeah.
So it's not changing it. So I mean, mix of both.
That's kind of unusual. Thank you.
Yeah, DMV's new counsel and I have been in touch since early in the fall, going back and forth over sections. She has a fantastic eye for detail and finds things that don't make sense. And then we get in touch and we discuss the language and whether there's a potential change. We looked at the language as it was going into the updates for the green books too, finding issues in the statute with the way it had been printed out in past years. Fantastic resource for us here at the legislature too, having a second set of eyes that's going over some of these things that often get lost in the green books. So that's where a lot of this comes from, or some of this comes from, and it's helpful because it means that hopefully a layperson can read this and figure out what it means without having to call in 2 or 3 friends to help them translate. So with the next changes here, we are adding in the definition of mail, the cross-reference back. So purchase and use tax is in Title 32, but it governs motor vehicles, which are under Title 23. So we've added in a cross-reference to the definition of mail in Title 23, which you updated last year. And so this is just making sure that you're reflecting the way the DMV can mail things under all of its other statutes for purchase and use. And then the change in 6 is just to bring that within our current drafting style. And then with the education and appeals piece here for purchase and use tax, I've taken out some of the legalese, and then we're adding in the real substantive change is on page 47 here. Commissioner shall establish procedures for taxpayers to file an appeal regarding their liability, and the procedures shall include a process to resolve the dispute prior to a final administrative decision. In other words, to basically come to a settlement of the dispute. And then the commissioner shall create educational and outreach materials. And so this, as I understand it, is basically blessing work that the department is already doing on this. And this gets back to the whole issue of valuation of your vehicle when you go in for purchase and use tax. And so it's kind of dealing with that issue. Questions?
Anybody else anybody have any questions on that piece or? Okay.
Okay. The next change is a technical one. So this is your points assessment schedule in 23 BSA 2502. Currently, the entry for 8 points. 8 points are assessed for violations where you're more than 30 miles an hour over the speed limit. It had a cross-reference to 2 out of 3 sections involving violations that are more than 30 miles an hour over the speed limit. And so we've added in the third, which was missing. Questions? Okay. Oh, the next one's good. Tinted windows. So this is 4 sections here. So I'll explain it sort of overall. So in last year's motor vehicle bill, there was language enacted to reflect. So we already currently have prohibitions on covering your windshield or the windows to the left and right of the driver, including vent windows that might be in front, even though cars don't use those windows as vents anymore. We already prohibit covering those up with something that would obstruct the driver's view, and tinting material, et cetera. But we've never really set what the limit is. This varies state to state, but the federal requirement is essentially 70% visual light transmission. Last year, the way that this was phrased was to refer to a federal regulation that then refers to, I forget how long the document is, but the SAE, the Society of Automotive Engineers, puts out a document that has all of the requirements for motor vehicle windshield glass and for the windows. So it's structural requirements, thickness, obstructions, et cetera, and including tinting. And buried in that is the 70% visual light transmission. DMV was working on the regulations and found it very hard to, and this is me paraphrasing, but to decipher exactly what was intended. And came in with a proposal to repeal last year's language. The Senate did not want to repeal the 70% visual light transmission requirement. And so instead they pulled out what was in last year's bill and they're replacing it with sections 39, 40, and 41 of this bill, which instead of cross-referencing the federal statute, puts in shading or tinting material, and the visual light transmission of the windshield, vent window, or side window with that shading or tinting material cannot be less than 70%. So this means that 70% of the light outside has to come through the windshield to the interior. Does that make sense? So for reference, a pair of dark sunglasses is like 12 to 15% visual light transmission. If you've got those rose-colored sunglasses, that's probably more like 60%. So it can be tinted slightly, but not enough to reduce visibility in like dark conditions and that sort of thing. And that's where the standard is. And then the rest of it is just cleanup that we did in last year's bill that's been put back in. And so the rest of these changes were all things that you put in last year, subdivision heading or subsection headings, the requirement that remove the material if it bubbles or tears or is otherwise worn in a way that would limit clear vision. And then we define visual light transmission. Section 40 sets out the intent, and this basically mirrors last year's language, that shading or tinting in excess of what's permitted under the law is a danger, and that those vehicles that are tinted beyond that point would fail annual safety inspection. And then Section 41 is the rulemaking requirement, which would require the rules to be effective not later than July 1 of next year. And then requires also public outreach on these prohibitions. My understanding is that there was a great deal of testimony on this last year. There was some testimony this year. And so you'll likely want to hear from the department and other parties on this issue. And I won't go into the various points of view that were expressed to the Senate there, since I'm sure you'll hear it better from the witnesses when you have them in. Questions?
I'm trying to remember, is it the intent that, at our annual inspections, that the inspectors will be able to measure this 70%?
So that's when it would be measured. There is, this would require it to become part of the inspection manual. My understanding from Senate testimony, not from personal knowledge, is that you can purchase devices that measure visual light transmission. And I believe the number that was quoted frequently in the Senate was around $40. But again, you will want to get witness testimony on this, on the availability of those devices, what they actually cost. And this would be an expense. Yep, calibration, and it is an added expense for inspection stations. So, or for the state to provide the devices if that were your intent. So there is, these devices cost money, and they will need to get purchased in order to allow inspections to occur.
So failure is dealt with at the inspection and not by any law enforcement?
No, this does not provide for the law enforcement there. If we look back at that language, it is worth noting that law enforcement, this does say you shall not operate a motor vehicle. Law enforcement can pull you over for overly tinted windows the same way they can pull you over for an overly loud exhaust or something else that they deem to be a violation. The extent to which that actually happens in Vermont, I don't know. There was a question in the Senate about whether some of this language here was making, and there was also a noise bill, which I think has come over already. There were questions about whether this was making it like secondary enforcement, and the answer is this is not changing the right of a law enforcement officer to pull you over if they believe that your vehicle is unsafe and violates one of our requirements. But generally, the place where this is tested is going to be inspections. Theoretically, law enforcement could enforce that requirement. So you may want to hear from law enforcement or other groups about the requirement here and whether that's a concern. And it's worth noting that other states, not every state enforces this at inspection. I believe there are some states where it's expressly enforced by law enforcement. And then there are others where it's an inspection issue. So, but that would be a deeper dive, which I can do for you if you need information on that. There's actually a witness the Senate had last year provided a handy reference to the vehicle tinting laws in every state, which someone in the industry put together. Since, as you can imagine, shops that sell tints have to know that and at least be able to tell their customers, you know, if you get this tint, technically you'd be in violation of the law, but if you want to buy it, that's up to you. So,
And just to clarify, Damian, this is not a new law, but it is a law that was previously referencing federal law. So we're putting it all into Vermont law here.
So what we did last year is right here where we got this number 7. The rest of the law is existing, and we essentially left it as is, except for some of the changes we showed later on where we moved around the language about bubbling, tinting material, and so forth. Last year, we said if the object is shading or tinting material, that actually, I can't remember the exact phrasing, but it essentially referenced this federal regulation, and it said if it's not consistent with that, it would violate the law. And the problem is that federal regulation goes broader than just tinting, goes into all of the requirements for a windshield. And then it references this SAE engineering document, which goes even broader and even more granular. And so the difficulty in writing the inspection manual is that these are the requirements for manufacturing a vehicle and selling it in the US. And so a lot of this is done at the OEM, like manufacturing stage. They're figuring out if their windshields are going to comply. The manufacturers purchase windshields that comply when they sell their vehicles in the States. So the aftermarket, you can apply tinting material to those windshields. You can also purchase an aftermarket windshield or, a side window for your car. And so this is basically saying what we really wanted to get at was this 70% light transmission. We don't want to prohibit any car coming off of a dealer's lot. But the intent, as I understood it, was to prohibit cars from being darker than you could buy them from the dealership. So basically, you can get a reduction of up to 30% of the light transmission in a new car, but you can't go beyond that. And that's basically where they're setting it out. And this was based on sort of the auto dealers coming in and saying, please don't prohibit cars that we're going to be getting from the manufacturer. We don't want to have to then police the cars on our lot before we sell them.
And will this fail inspection or no?
Yeah, this would be a
This would actually
inspection.
fail.
If you're at 68% light transmission,
Yeah.
you would fail.
So I know before we sort of separated it out, they could still pass, but they would be given a warning, if you got pulled over, you're still in violation. They would not.
Right. And there's a lot of testimony from last year that I don't think I can paraphrase fairly, because I'm sure I'm going to leave things out, but there was a lot of testimony about how the law was being enforced before.
Yeah.
And issues prior to the latest version of the inspection manual, and the way the inspection manual used to be drafted and so forth. And it really went into depth. And I know at least the Senate spent a lot of time on this last year. I didn't look at what the House committee did. And so it just,
Oh, yeah, no, we.
Yeah. I know when over in the Senate, Senator Perchlik asked me to go back and look at the testimony they'd gotten last year on this to get a basis for it, because I think they added it into last year's bill. And then I'm sure you went through it too. So that's all just to say that it's more complicated than just a number. There's a lot of background to this, but I'm not qualified to provide that testimony. So. And there's also, it's worth noting too, there was also testimony this time around on whether the rulemaking timeline works. So, the commissioner can speak to that for the department. So the Senate chose to go with the timeline that was set last year, and to keep that. The department had requested a longer timeline. So they can speak to that going forward. Okay. Moving past the tinted windows, we are so close to the end here. This next one is a really easy change. The definition of all-terrain vehicle, or ATV, for purposes of our ATV statutes, is increasing the width of those vehicles from 64 inches to 72 inches to reflect that the vehicles are just getting wider. And so this ensures that you don't end up governed by the motor vehicle statutes instead of the ATV statutes if you're purchasing a new Polaris or something like that. Yeah, the UTVs are the ones that are running into this. Sorry.
So I read this several times and I thought for sure we were talking about tires that were 72 inches wide. And of course, that doesn't exist. You're talking about vehicles. Not having not less than two low pressure tires, but two doesn't make any sense to me at all, why you'd have two or less. But not wider, and so you combined the pressure, the tires with the width of the vehicle, which I think is implied. Is that right?
would agree to you that, or agree with you that the way this definition is written, I had to read it a few times to pull things out, and it really comes down to the use of commas and semicolons.
All right.
If the committee would like, when we get to the point of amending the bill, I can attempt to rewrite the definition so that each requirement is broken out into its own little subdivision, and that I find that makes these things easier. The request on the other side of the building was simply to make this change from 64 to 72 to make sure that we were continuing to capture these, what Representative Casey called the side-by-side ATVs, which are getting wider for more stability. And so they will still be able to use the trails at this width, but it also means that you won't have two vehicles sitting on the lot that are different by a couple of inches, both common models from one of the major manufacturers here. And one is under the ATV statutes and the other is not.
Well,
Any idea, you probably can't answer this question, but perhaps, well, I'm just wondering about the fiscal impact, actually, just with the revenue capture.
I don't think that Logan identified one in the fiscal note, but he's the better. I don't recall seeing one in the fiscal note, but Logan would be the better person, and the department too can answer whether they think.
But we'd be keeping up some sort of an industry trend.
We're keeping up with the trend here to produce wider vehicles because when you spread the wheels apart, you create a more stable vehicle. So that's really just the aim here. They're essentially more stable, likely safer because of that, less likely to roll over.
due to the towns that are having arguments about what you can and can't drive on the roads, what does this impact?
So this doesn't change any of the requirements about the operation on a public highway. And you'll notice here down on lines 14, an ATV on a public highway shall be considered a motor vehicle only for the purposes of certain offenses. It doesn't change any of that. It doesn't change the requirements around municipalities' rights to regulate which roads and so forth. It really is getting into just tracking that industry trend towards making wider 2- and 4-seat all-terrain vehicles.
I share your concern too. It sounds like we're expanding what an ATV is by doing the side by sides. That was a big issue in a couple towns, especially in Bennington, where you saw these side by sides more and more frequently on public roads. And the previous commissioner and deputy commissioner were clear that they weren't allowed. But now we're recategorizing them to be an ATV because they're sort of lumped in. So it sounds like it does have an effect.
Yeah, I mean, I think the 72-inch width is going to capture that side by side. I think
this is as simple as probably you might have.
Yeah, so you may want to dig into this more deeply.
Yeah, I'm not a user, but my communities are really sensitive to this area. I don't know much of anything about them, but I know that it is a regular topic at every very regular topic. It's a big issue about where you can drive and where you can't, and they're up and down the public highways or if they're the town roads, et cetera. I don't know much about it. I know it's important to the people in the area I live. And that's my concern. So Representative Casey.
I did help get them on our roads. I know that was it Governor Shumlin during his time that something happened where get a model of, law for the towns to use. And that's what we grabbed and I think since then Whiting's done it all around my areas. Four-wheelers and ATVs are a big deal. People run them around like cars.
And this makes this more able to make this happen or less able to make?
I don't know. I was just saying it. I was just
So-
speaking. It wasn't.
Side by sides, yeah.
So,
I don't,
Yeah.
I don't know how to fully understand.
Yeah.
I'm not gonna do anything that's gonna.
Yeah.
Yeah, but it's
going to increase,
people, and this will definitely.
yeah, so this
I
is
gotta make sure
gonna,
I fully understand what we're doing before I go anywhere. But I was like,
yeah, this doesn't change some of the underlying laws there, but it will increase the vehicles that qualify as an ATV. And so that's really the question here is what's the impact of that? And whether you agree with that as a policy direction. So I, like the chair, I don't have a lot of experience with ATVs. And I'm certainly not the witness to answer a lot of these more substantive questions about that. I can get you background info on the laws around the use of roads and how that works. But you're probably going to want to hear from the department and other witnesses on what the impact is going to look like. Maybe you may want to hear from the League of Cities and Towns, from the ATV users group, and I'm forgetting their name today, and that is
So,
VASA. Thank you. I knew it was VAS, and I couldn't remember. I wanted to say VAST, but wrong trail network.
yeah.
But yeah, VASA will likely also have some information on this, and the dealers may have some information for you too. So,
Representative Powell?
But on the surface, this doesn't change. I mean, it's up to each municipality to decide whether on their roads and which roads they would allow ATVs.
yeah, it doesn't change anything about that process, but it does change what qualifies as an ATV. And I would have to do a deeper dive into that process to see whether there is ability to limit based on size of ATV and so forth under that process. I just don't know. So this will be a good excuse for me to get to know that law better.
I know the town of Highgate, someone that spent a huge amount of time and energy on that, and
And they allow
I didn't pay any attention because I don't actually care whether they do or don't drive on the highway. I don't. But I'm gonna find out before we do anything,
Yeah.
what the opinion of the towns are, but they have been struggling with this for a long time. Maybe not, maybe this has no impact, but we're gonna certainly find out, before we do anything.
Okay.
There aren't very many that are big, really get people excited in our area. This is one of them.
Right. So much for my thinking, that was just a simple little change.
I don't know, maybe it is. I would say maybe it is, and I hope you're right. I'd like to know it before I do it.
Definitional change on the.
But it seems to allow a lot more, I mean, that's where 8 inches is may or may not make a big deal on classification of how big a vehicle is.
You can also buy like offset rims, and make them so they stick out further to probably increase your stability even more, I'd imagine, but man, you know, when you buy something.
Secondary, hey, we just got off tinting, if you want to talk about secondary market, right? Tinting is a secondary market big time, so I'm sure there are people, I don't see them in my area that care about tinting, but boy, I just went through Springfield, Mass, and they got a whole different opinion of what they should do with their vehicles.
It's about law enforcement.
Yes, sir. Just I don't know towards this. I think this was Vax that brought this proposal to the Senate. Talking with them, they're just moving to an industry standard, I guess, whereas on they're not increasing the size per se of the actual vehicles, it's tires that are making it more like larger. I think that's probably your best witness when needs to come in, but I think that was from.
Oh, thank you for that. And I misspoke and my chart is wrong there. I had thought that was a DMV proposal, but it was just in the original draft, so I assumed it was a DMV proposal. But yeah,
They just sat around for 3 days. Finally got time. Get his name. I'm trying to find.
yeah, okay.
We didn't finish 43 then, did we?
No, 43 is the last substantive section in the bill, and I'll get you out of here quickly. This is directing, creates a study committee that does not involve any legislators. It is got the Commissioner of Motor Vehicles or the Commissioner's designee, a member appointed by the Vehicle and Automotive Distributors Association, the Insurance Agents Association, and the Vermont Community Action Partnership. And they are supposed to study the assessment of the purchase and use tax and the inspection of motor vehicles whose onboard diagnostic malfunction indicator light is on, including potential fiscal impact on the state of assessing the purchase and use tax against the amount that a used vehicle was purchased for rather than the clean trade-in value, the potential for assessing the tax against the amount that it was purchased for if the difference between the purchase price and clean trade-in value is equal to or less than the cost of repairs necessary for the vehicle to pass inspection following purchase. The assessment of purchase and use tax on vehicles that were purchased and first registered in another state. So in other words, you've moved here from another state after purchasing and registering your vehicle there, including any potential impacts that the current manner in which it's assessed on those vehicles may have on owners' decisions to move to Vermont or register their vehicles in Vermont or both. Potential changes to the statutes regarding the purchase and use tax to mitigate any negative impacts identified. And then potential modifications to the periodic inspection manual to permit vehicles whose onboard diagnostic malfunction indicator light is illuminated if the issue causing the light to be illuminated does not affect the safety of vehicles. I'm going to note with that last one that on the very last day after this vehicle had passed out of the Transportation Committee and was heading to the floor, some of the language in here was amended, and one of the senators highlighted, and then we went into a discussion on the inspection manual, that this last piece, the inspection manual, may not actually have any non-safety malfunction indicator light failures in it. So it would be worth potentially getting additional testimony on whether there's actually an instance where you could fail inspection for a non-safety issue with a light being on your dashboard. So there are instances where the light will come on for something that's not a safety issue. And there was, it wasn't clear on the last day, but there was a question about whether there's two instances where the inspection manual includes a malfunction indicator light as a reason for a failure. It's not clear whether either of those would have a non-safety issue tied to it. And I'm certainly not the person who can answer that question. So you're likely going to want more testimony on that. So like I said, no legislative members, no legislative staff. It would be staffed by DMV. Reports due next January. And anyone on the committee who's not otherwise compensated for attendance would be entitled to per diem compensation and reimbursement. And then the only effective dates that are pushed out are the tinting sections, since the rulemaking wouldn't be due till July 1, 26. The effective date of the law changes was pushed out to July 1, 26. Everything else is July 1, 25, and it's lunchtime.
Well done.
Okay. That section 43 is regarding inspections. I know that we have a big section on education piece on how inspections work, inspection process, et cetera, all they go through. There are at least 2 bills up on the wall that have inspection related reviews, and so we're going to get significant education on that entire process. With that, Damien, thank you very much. Commissioner and designees, as I guess we're learning to call them. Thank you for joining us, Damien.